An information misdemeanor complaint and a felony complaint must each specify name of the court where it's filed, title of action, subscribed and verified by a person known as complainant. He may be any person having knowledge, whether personal or upon information and belief, of the commission of the offense. It must contain accusatory part and factual part. In the case of an indictment, an instrument may charge two or more defendants, provided that all defendants are jointly charged with every offense alleged therein. Where a felony complaint charges a violent felony offense, and such offense is an armed felony, the accusatory part of the instrument must designate the offense as an armed felony, and the factual part of the instrument must allege facts of an evidentiary nature supporting or tending to support such designation. This next thing was actually talking about a citizen's arrest, which I don't even remember ever reading that, but it just says that like when it's a cop, they do the transmission of the papers to the DA, but when it's like a citizen's arrest, apparently the clerk of the court does it. So supporting deposition, that's 30 days plus 5 days before trial, whichever is sooner. Prosecutor's information must be subscribed by district attorney. Court may order amendment of accusatory part of the information by addition of account charging an offense supported by the allegations of the factual part of such information and any or supporting depositions which may accompany it. So for New York City Criminal Court, District Court, or a city court, any local criminal court accusatory instrument can be filed in a city court, District Court, or New York City Criminal Court. And it says that an information, simplified information, prosecutor's information, or a misdemeanor complaint may be filed with a village court of a particular village when an offense charged therein was allegedly committed in such village. 6. A felony complaint may be filed with any town or village court of a particular county when a felony charged therein was allegedly committed in some town of such county. Such court need not be that of the town or village in which such felony was allegedly committed. Everything can be filed with a judge sitting as a superior court, judge sitting as a local criminal court when offense charged was allegedly committed in a county where the judge is then present and in which he either resides or is currently holding or has been assigned to hold a term of the superior court.
That does not look good.
All right, so the warrant of... Let me see if I can do this. The warrant of arrest has to be subscribed by the issuing court, state the name of the court somewhere on it, state the offense charged, have like a description of the defendant or his name or something, I think. No, there was like more stuff to it. And a direction to the officer or something to arrest the defendant and bring him to court. So a warrant of arrest must be subscribed by issuing judge, state or contain the name of the issuing court, and date of issuance of the warrant, name or title of an offense charged in the underlying accusatory instrument, and D, where name of defendant is to be arrested or if he is unknown, any name or description by which he can be identified with reasonable certainty, and E, the cops to whom warrant is addressed, and F, a direction to arrest him and bring him to court. Multiple copies may be issued. May be filed with the town court of any adjoining town of the same county. Such instrument may be filed pursuant to 100.55 with a village court, and the village is not available at the time. It could be. The warrant of arrest may be issued only by the local criminal court or youth part where it was filed, and it may be returnable in such issuing court only. Then it goes into a thing about what cops may arrest the guy. I can't even bring myself to read that. So here we go. A warrant of arrest issued by District Court, New York City Criminal Court, Youth Part of Superior Court, or Superior Court judge sitting as a local criminal court may be executed anywhere in the state. If he does not have the warrant, he has to show it to the defendant as soon as possible. Oh my God. Okay, there's a 2-hour rule in here, and here it is. Something about there's a 2 hours. Hold the defendant for 2 hours. upon arresting the person. Okay, and this is a new thing, I think. It says you can get a phone call unless granting the call will compromise an ongoing. All right, this is 170.25, divestiture. At any time before plea guilty or trial starts, or within 30 days of arraignment on an accusatory instrument, the guy can ask the superior court to prosecute him by indictment, even though he's only charged with a misdemeanor. And there's a 45-day rule in this. Has to be ROR'd unless good cause or his request, action, or condition. The grounds for dismissal in 170.30. 1, defective. Oh, so 1, defective. 2, immunity. 3, double jeopardy. 4, untimely. 5, denied right to speedy trial. 6, justice! Interest of justice! I think that's all of them. Is there a 7th? There might be 7. Oh, no, there's one more. And now here we go to 170.30. A, defective. B, immunity. C, double jeopardy. D, untimely. E, speedy trial. F, jurisdiction, legal impediment. G, furtherance of justice. To make that motion once, raise all your grounds in it. Okay, you cannot issue, what does this say? Oh, you can't get ACD if you had a commercial learner's permit or driver's license. Okay, so now I'm back in 190, and there's something in here about like a chemist, coroner, something like that, about the evidence, and it just says something about 20 days. So there's a 20-day rule in there, and I think it has to do with like if they're like emailing a certified copy of some report or something, or whatever. It's 20 days. All right, so I looked at it, and it has to do with the 20 days that they're talking about is like the actual report, if it's like emailed to the grand jury, I guess, and then there's the actual certified copy of the report has to be filed within 20 days after the guy is arraigned on the indictment. All right, so this says something about when there's a court instructing jury with respect to evidence, legal effect, or evaluation of evidence, the DA in an equivalent situation in a grand jury proceeding may so instruct the grand jury. And I highlighted that because I thought it was interesting that it was a may, not that they have to. So the more grand jury stuff, each person present for a videotape deposition, except the witness, must, if he already didn't take the oath, he has to take an oath about the secrecy. And then he will keep the secret, the videotaped examination. Okay, so witness gives evidence. He gets immunity unless he effectively waives it or it's non-responsive. A waiver of immunity is not effective unless and until it is sworn to before the grand jury conducting the proceeding in which the subscriber has been called as witness. Okay, so this is just talking about how the DA does not have to tell you that you're investigating something unless you were arraigned in the LCC and you demanded that. In such case, they have to notify the defendant or his attorney of the prospective or pending proceeding and accord him a reasonable time to exercise his right to appear as a witness before the grand jury. Upon the DA of a notice requesting appearance, DA must notify foreman of such request, and he must subsequently serve upon the applicant a notice that he's going to be heard, and the time and place. He has to sign the waiver of immunity. If it's obtained in violation of this section, it's invalid, but the guy has to raise it by motion within 5 days after defendant is arraigned upon indictment or on prosecutor's information resulting from this. Otherwise, it's waived. Okay, and then it says that if, I guess, the defendant wants the grand jury to hear some witness, the grand jury may, as a matter of discretion, grant such request and cause such witness to be called pursuant to sub 3. This section does not apply. Okay, then it's talks about a subpoena. Where a subpoena is made, and any motion to quash, fix conditions, modify or compel compliance shall be kept secret and not disclosed to the public by any public officer or employee or any individual in 215.70 penal law. This subdivision shall not apply where the person subpoenaed and the prosecutor waive the provisions of this section. All right, so that is something I also didn't know. Grand jury attorney for witness. The witness that signs a waiver of immunity gets a free attorney if he's indigent. The attorney may advise the witness, but cannot object, basically. He can request to confer with his client. Okay, so grand jury may indict a person, direct DA to file a PI, direct DA to request removal to family court, 4, dismiss charge, 5, submit a report. So this is about if the evidence is not sufficient when corroboration is required as a matter of law to sustain a conviction is absent, and B, competent and admissible evidence before it provides reasonable cause to believe the person committed the offense. Upon voting to indict a person, the grand jury must, through its forum interacting foreman, file an indictment with the court by which it was impaneled. So when they indict a person, it has to be for such offense. So it is a little different than the felony hearing, because the felony hearing is just any felony. Then it says something about they must file direction with the court to file the PI. The court must, unless it's insufficient, issue an order approving the direction. All right, so this is that crazy 90-day rule about how he's got freaking 90 days to notify the guy that the case is dismissed to his last known address by regular mail, unless resubmission has been permitted, or an order of postponement of such service is obtained upon a showing of good cause and exigent circumstances. So that's if it's dismissed. Then the public servant, there's a 31-day rule in here, not 31 days. They can file an answer not later than 20 days. This is for the public servant. Court finds filing is a public record, might be a problem, then they can order it sealed. Okay, so this is something that I've always been a little tricked by. It said, the way it's worded, it says waiver of indictment is okay if he's held for action in grand jury and he's not charged with a Class A felony punishable by death or life imprisonment. So now I'm not sure if every Class A felony is punishable by life imprisonment. And then the DA consents. So, who knows? Maybe it's semantics. Joinable, including petty offenses. One offense only. If they fuck up the subsection in ways that, different ways the offense may be committed, it can't be amended because it's considered to be charging more than one offense. This is for the joinder. They may be charged jointly if they're all charged with the same thing, with every offense, based on a common scheme, same criminal transaction. And those are all ors.